you just inherited a house in Florida, pause before you list it, before you clean it out, and before you even call a realtor who doesn't do this every day. There's a legal process that decides whether you can even sell that house right now, and getting it wrong can delay your closing by months. I'm DiPaolo with eXp Realty, and I'm probate certified right here in Central Florida. Let's walk through exactly what you need to know. What probate actually is. Probate is the court process that transfers a deceased person's assets, including real estate, to their heirs or beneficiaries. In Florida, if the house was only in the decedent's name with no trust and no joint owner, it generally has to go through probate before it can legally be sold. There are a couple of exceptions like a ladybird deed or protected homestead passing directly to a spouse or heir, but outside of those, probate is the path. There are two main paths here in Florida. Summary administration. This is the faster, simpler option. It's generally available if the estate is worth less than $75,000 or if the person passed away more than 2 years ago. Formal administration. This is the standard process for larger estates, and it's what most families dealing with a house end up using. The court appoints someone called a personal representative to manage the estate. Testate versus intestate. Before we go further, there's a term you'll hear a lot. Testate versus intestate. Testate means the person left a valid will. Intestate means they didn't. If there's a will, it typically names who the personal representative will be, and it directs how the house and everything else in the estate gets divided. If there's no will, Florida's intestate succession law decides who inherits based on marital stats, children, and other family relationships, not on personal wishes. Either way, if real estate is involved, probate is usually still required to legally transfer that property. The will just determines who steers the process and who receives what at the end of it. So who can actually sell the house? This is where I see the most confusion. Just because you're the child, the spouse, or the next of kin, it does not automatically mean you can sign a listing agreement or a contract. The personal representative, sometimes called an executor, is the only person with legal authority to sell estate property, and even then, that authority depends on what's called letters of administration issued by the probate court. Some personal representatives have full power to sell without further court approval. Others need to go back to the judge for permission before closing. Your attorney will know which situation applies to your estate, which is exactly why I work hand in hand with probate attorneys on every one of these transactions instead of guessing it myself. Timeline and what to expect. Families always ask me how long this takes. Realistically, summary administration can move in a matter of weeks. Formal administration is typically several months from filing to the point of where a sale can close. Sometimes longer if there are multiple heirs, a will contest, or unclear title. That timeline matters because it affects pricing strategy, showing timing, and how to structure the contract. A probate sale isn't marketed the same way as a typical sale, and buyer's agents need to understand that going into it. Common mistakes families make. There's 3 mistakes I see constantly. Listing the house before the personal representative has the legal authority to sell it. That contract can fall apart later, causing a lot of stress for everybody involved. Making major renovations or repairs before understanding the estate's financial obligations, since the estate may owe debt that has to be settled first. And then pricing based on emotion instead of data. I build condition-based pricing scenarios for every probate listing so heirs can see exactly what the house is worth as is versus what light updates could bring before anyone spends a dollar. Why this requires someone who specializes. This isn't a typical listing. It touches estate law, court timelines, multiple heirs who don't always agree, and title issues that a general practice realtor may not catch. In nearly 8 years as a realtor, I can count on one hand the number of other agents I've come across who are actually probate certified, and it's just not a common specialty, and most listing agents are learning the process for the first time on your file. I hold a probate certification, I'm a member of ORA and NAR, and I work directly with a small group of trusted probate attorneys across Hillsborough, Pasco, Polk, Seminole, Orange, and West Volusia counties, so families can get one coordinated team instead of piecing it together themselves. If you've inherited a property in Florida and you're not sure what happens next, don't guess and don't wait. Message or call me directly directly at area code 813-951-0657, and we'll walk through exactly where the estate stands and what your options are at no cost to you. Stick around for more probate videos and this video series.